very much for having me here to speak again. It's a tremendous honor to be here with you, Mary Lou, and the Walker team. It's been 15 years since I started my relationship with Walker, and it's been, the most thrilling experience ever. Entrepreneurship, building a trial firm. I remember Mary Lou always talks about it. The first check I ever wrote, $5,000, my hand was shaking, and then there's been times that we did $500,000 or more together, and sometimes whatever, bigger than that. But it's an honor to be here and to be able to speak among some of the nation's top trial lawyers who've not only achieved magnanimous numbers, but who have done tremendous things to shape safety and to create change and reform in schools, products, vehicles, civil code, case law, making the world a better, safer place, and really improving the platform for trial lawyers and owners of firms like us to be able to perform on and to be able to do a better job for our clients. Some of us do things. I'm on many political action committees. We do lots of things to help, raise the policy limits for you guys. In 2025, the good news is all your 1530s are going to be 3060s. That'll be very exciting news. So yeah, lots of exciting things coming up. They tried to beat us. The insurance lobby tried to really mess with us on the demands. We have a deal together on a bill where the demands are going to be safe. All we have to do is give them 30 days if it's sent electronically, 33 days if sent by mail, and really nothing else changes. You just need to include the claim number, policy number, et cetera, and address it to an actual adjuster. So we're safe there. They were doing everything they could to take away our ability to open up policy limits, but we made a deal with them, and it looks to be shaping up positively. We're in the business of law. California is under siege. Dr. Nick knows this number better than anybody else out there. Where's Dr. Nick? Yeah, what's the total PI dollar value in the United States, and how big is California in comparison to that?
$7 billion annually, $22 billion in California.
Wow.
So 2/3 of the entire nation's PI economy is in California. They want us. We're constantly under siege. So it's very important that we all stay unified. They're coming after us. They want to do big things, the big corporations. They're going to try to attack our fee structures. It's very important that we all stay unified and be receptive to coming together and help each other out. But I want to talk a little bit about each one of the trial lawyers who are going to present for you guys tonight, and I'll jump in and give some of my feedback and some of my thoughts. But our first speaker, Rahul Ravipudi, big trial lawyer. I had to cut down probably 80% of his bio, but back to back, Consumer Attorney of the Year finalist, CAOC. One of those was a case that we did together. Top plaintiff lawyer in California, Daily Journal, Law Dragon, Top 500. It just, you name it, he's got the award. Not only him, but the other trial lawyers in his firm. I think everybody here knows who Rahul and his firm, who the players are. Aboda, these guys teach. They're the masters of the game. I'd really love for you to come up here and share some knowledge with everyone. Everyone's excited to hear you speak about some of the things that you've done on some cases. I have one that I can talk about very briefly.
Go for it.
Yeah, if you want to come up here and we can talk about it together.
Believe it or not, this is going to be the first one we're going to talk about, too. So.
Yeah.
Hi, everyone.
Oh, really?
Yeah.
Timing?
Yeah.
Okay, so
yeah.
something like maybe 4 or 5 years ago, I had a case come across my office of a very traumatically injured boy. He was maybe 7 years old when the accident happened. Potential client has his mom call, listen, our kid is walking home from school one day, and he's on an IEP program, and part of the IEP program is that he's required to be walked to and from the bus, and the bus is supposed to drop our kid off at school. On this day, the kid was not taken to the bus. There he is.
I'll show you.
He was allowed to walk home.
Oh, wow. Oh, jeez.
This is completely unplanned, and look at how that happened.
Yeah, he's narrating for me. This is perfect.
And there's video of the kid.
Here's the video. All right, so here he is right here.
This boy was 7 years old when this accident happened. This case was shopped to over a dozen firms before it came to me. We wrote about it on the Cala listserv. Everyone had heard about it. Fuck this case. We don't want it. We dropped it. No problem. We hung on to it for 3 or 4 years. John Teller worked it up impeccably. Got it to a point where it was ready for serious, heavy lifting. We called Rahul.
Take it away, Raul.
Okay. No, thanks, Bobby. Okay, so what I want to talk to you all about today, and I was trying to figure out what would be a fun topic and something hopefully there could be some takeaways from. And that's always my goal when I'm talking to anybody, is I hope I can give you some tools that you can use and execute on immediately. And comparative fault is something we deal with in every single case, right? So you get a case, you think it's like a clear rear ender, truck hits a vehicle. Obviously, the defense is still going to argue comparative fault, right? Plaintiff broke too soon, got in my way, whatever it is. So even on the simplest cases, it feels like we always have to deal with comparative fault. What I want to talk to you about is how we stop even worrying about it and change the framework on what comparative fault is, and ultimately force the defense to either give it up and say we're not going to argue it, or face the consequences. I talk about it in this way. It's called the single point of failure. In a lot of these cases, including the one I worked with Bobby and John Teller, there are multiple targets, there's multiple defendants, and that creates an opportunity for slicing and dicing nonstop. And so what we always need to go through is this exercise of this identifying where in the chain did the break happen and cause all the other breaks to happen afterwards. A lot of people call it a root cause analysis. But this single point of failure is what helps get us to the point where we can put the blame where the blame belongs on the defendant and hold them 100% responsible. So I want to go through with the time I have, and if I get cut off, I apologize, but I will talk to any of you and all of you at any time about this, about different kill shots. First one is committing to a target. And we talked a little bit about this case, Fabian Sanchez, Victor Elementary School District, and I'll jump right here. But one piece of information that came up here is Fabian's mom was at home. They had an 18-month child, and Fabian's mom texted Fabian at the end of school and said, "Hey, walk home." And so it's Fabian's mom that caused Fabian to walk home and then ultimately get struck by a vehicle driven by a gentleman, Raul Martinez. And Mr. Martinez worked for Century 21 and a subsidiary of Century 21. He didn't do any work for Century 21 as a real estate agent that day, but he did have some files for escrow papers in his car, so there was a potential course and scope of employment argument that could be made. So in this case, we've got so many different potential defendants, right? You got Raul Martinez, Century 21, State of California, City of Victorville, dangerous condition of public property type theories on this roadway, the school district, and FCL, it's Felix Lopez and Associates, but that's the Century 21 entity. All of them were named defendants in this case. So what happens when you have multiple defendants in a case? And how do they behave? They behave a little differently than, and it's always been counterintuitive to me, but it's starting to make sense. They like to stay in their lane. Hey, defendant 2, you don't blame me, I don't blame you. None of us are going to get held responsible, and we're all going to get out of this case nice and clean, okay? So don't start the crossfire. That's what the plaintiffs want, and when everybody starts blaming each other, we're all going to take it together. So let's just stay in our lane. Okay, so now we need to commit and get them to commit. So we've got all these parties, and we wanted to put the target on Victor Elementary School District. Why? They had an IEP. An IEP is an individual education plan, and that plan requires the school district to do certain things that are contained within it for a child with disabilities. In their plan, they had curb-to-curb transportation. A school bus should pick Fabian up from school, drop him off at home, right in his driveway, and vice versa. In the morning, pick him up from his home, drive him to school. If he was on the bus, this tragedy doesn't happen. And so that was what we decided was going to be the target defendant in this case. And here's the IEP document for Fabian. And as you can see here, it talks about curb-to-curb transportation right here, and that he's eligible for it. And this is the education code that talks about IEPs and says that whatever components are in the IEP must be effectuated by the district, not the mom, not the dad, not any friend, nobody, just the school district. And they need to implement them immediately. So this is the school's responsibility to do, and they're the ones that we felt were responsible. Now, in talking a little bit about comparative fault and this back chaining and looking at that single point of failure, what we really want to look to is systems and processes. That's what keeps people safe. It's not that split-second decision or that 2-minute decision from the time mom texted Fabian and said come home, or when Mr. Martinez was driving and Fabian darted across the street. Once we fight in that world, we're in that woulda, shoulda, coulda hindsight thought. What if Fabian just took a half-second longer before he crossed the street? What if Mr. Martinez was driving just a couple miles slower? What if mom didn't text Fabian? And when we get into that world, I call it the blender, and everything gets mixed together and the blame gets spread evenly. Some people call it the purple box. There's a lot of different things, but we need to stay out of that moment in time when the actual tragedy occurs, and we need to focus really on all of the opportunities and missed opportunities that allowed such an event to even be possible. Okay? And then once you have the blender, it just spews all over there, and then you get this terrible compromised verdict, right? So let's talk about how we do this and how we stay focused on Victor Elementary. First thing we want to do is we want to actually get everybody to commit. Because they're staying in their lane, I served requests for admissions to Victor Elementary School District and said, admit the other defendants are responsible, that they're negligent. Denied. But you ask it in the converse too, right? Admit they were not negligent. Admit. Did that for all of the defendants. Now that gives me freedom of choice, right? Now, if I dismiss Mr. Lopez, Martinez, anybody else, Victor Elementary School District can't blame them and say, there's the empty chair, that's who you should be blaming. So getting these requests for admissions out at the appropriate time, at the strategic time, then gave us the ability to then make decisions on what to do. So now, you've got the actual vehicle, driver, course and scope of employment, potential people, off the verdict form, and then I can negotiate with them and get them out of the case, which we did. So who's left standing? City of Victorville. Summary judgment. This isn't a dangerous condition of public property case. This is a case where Victorville got off on summary judgment. Same issue. No duty, no problem, can't blame them at the time of trial. So who are we left with? We're left with the fight, and are you going to blame Fabian, the special needs child? Hey, defense counsel, are you going to do that? Please tell me you're going to do that. No, we're not going to do that. Okay, Fabian's off. Now we got the fight between the district and mom. Okay? And that's important. So now the whole focus here is, and the spotlight is on the district at trial, whether they had a duty to implement this IEP. Now's the next question. Let's take ourselves back. This is probably terrible that I chose this particular case to talk about, because we didn't do this case in front of a jury. We decided that these types of issues of duty, this finite issue, is probably better for a judge to decide the legal fight between who's more responsible or who owes a duty to Fabian at what point in time. So we reached an agreement with the defense. Part of it was we had 14 depositions of damage experts teed up over a 2-week period, and they felt so confident they were going to win. We're going to win. This whole thing's a waste of time. Great. How about this? Maybe you're right. Maybe you're right and we lose. Why don't we just do a quick bench trial on this issue of duty? I win, we'll go to a jury trial on damages. I lose, we saved ourselves 14 depositions. Deal. Okay? So now we've got a bench trial in San Bernardino on this particular legal issue. We went in, and this is Carol Bartz, and this is the importance of taking these depositions and making sure that you get the concessions that you want. Carol Bartz was the defense expert on IEPs, and here's what she testified to about the importance of the IEP.
So if the IEP as executed in May of 2016 was implemented on February 3rd, 2017, Fabian would have been on a bus.
Correct.
And if he was on a bus, this tragedy never happens.
Correct.
Okay. And at no point in time was the IEP modified.
Correct.
Okay. Simple concessions from the defense expert, who, by the way, when I asked her, can you please just state your name? She's like, district didn't do anything wrong. I was like, okay, we'll get to that in a minute. But I just need to know your name first. So it took a while to finally get her to this point, but then she started conceding issues.
So you understood from Maria's testimony that she was very concerned about Fabian and communicated that to Mr. Hogan, correct?
Yes.
I mean, he knew through the impaired executive functioning that it was a significant risk to Fabian to be walking home by himself unsupervised, correct?
A risk, yes.
Okay, and a risk that is why he, as well as all the other members of the IEP team, recommended the curb-to-curb busing, correct?
Correct.
Okay.
And rightly so, you saw what happened on February 3rd, 2017, right?
Correct.
What was expected to happen when Fabian walks home unsupervised, correct?
Correct.
And it's horrible what happened,
Absolutely.
and it's heartbreaking.
Correct.
Okay, so what we talked about after that in some of the clips, and these are all slides from our argument to the judge, but was the concept of chain of custody. And I explained to Ms. Bartz, I said, hey, the school district had custody of Fabian, right? And their defense was, Mom texted him. Mom texted him. So if Mom texted him, that's fine. And I said, well, look, this is like Fabian's, you need to protect him, and you had custody over him. And if Mom or Dad came to the school, even though the IEP says curb-to-curb transportation, you can transfer custody to the parents at that point in time, right? Yes. But unless they're there, if they text the school or call the school or anything, you need to complete that chain of custody. That's your duty and responsibility. That's true. And when that ultimately came out and was conceded, the rest of this kind of fell into place. And so ultimately, the judge agreed with us and said the failure to implement the IEP was not only the cause of Fabian's harms, it was the sole cause, that Mom had zero comparative fault at all. And then the case ultimately settled for $28.5 million before our damages trial, which was pretty much all the coverage that the school district had. So kind of picking your defendant and getting everybody to commit to it, and then taking these steps to actually get everybody to commit so you can be fearless when you go into court and argue your case, is one of the concepts I wanted to talk to you about. Now, the second way to talk about comparative fault is through divergent timelines. Let me talk to you about that in this case, Jun versus Chaffey Joint Union High School District. And in this case, Jin was a 15-year-old sophomore at Chaffey Joint Union High School District, and he was 2 months into school. It's December, and he needed to go to the school bus stop. The school bus stop is located right up here at Serrano and Duncan Canyon. His home's right here. So he needs to cross this 4-lane uncontrolled intersection. And as he's doing that on December 10th, Imelda Hughes, who lives in the neighborhood, she wants to drive up to the park, which is all the way up here, to meet some friends. And so she's driving, and you can't see it, but it's about 1,000 to 1,500 feet of visibility. No obstructions, nothing. And Imelda's driving, and Jin's crossing the street, and ultimately Imelda hits Jin in the kind of like the 3rd lane and tragically kills him. Okay. So the case here, Imelda Hughes was charged with and convicted of misdemeanor manslaughter. And Mrs. Jun came in and met with me, and this is one of those cases, and there's been a few of these over the year where Brian gets mad at me. He's like, why did you take this case? And I said, well, I feel like the school district bears responsibility. And I think that that school bus stop should not have been where it was, and there should have been one on both sides. So I took the case. Case got dismissed on demur. It got dismissed on demur, went up on appeal, case got revived. And now again, on this particular thing, when we talk about that purple box, the blender, if we talk about the moments leading up to this, a 15-year-old boy crossing a street, he's 2.5 lanes in, a woman with 1,500 feet of visibility, where does everybody's minds go? Not to the school district, right? My position is they should have never met. They should have never had that opportunity to even get to interact with each other. So we stay out of that purple box. Here's all the different things, the woulda, shoulda, couldas that come up when you think about that little moment in time. So let's back chain to that root cause analysis. And the best way to do it in a case like this is looking at the divergent timelines. And I had this Code of Civil CCR 1238, and it says you can't designate a school bus on a multi-lane highway, which Duncan Canyon Road was, 2 lanes going in each direction, especially when it's uncontrolled and there's no stop sign. And so here we have the school bus schedule that the school bus designated a stop at Serrano and Duncan Canyon. I believe it's illegal. CCR says so. And here's what Al Regis said, who was the director of transportation at the time of this tragedy. Let's see if we can get this again.
So now going to Exhibit 2. You see Serrano and Duncan Canyon. Yes. Can you put a X at the northeast corner of Serrano and Duncan Canyon? Northeast corner of Serrano and Duncan Canyon. Yes, please. Thank you. Now, question is, where you've marked an X, is that a safe location to designate a bus stop? No. Why? Because of Duncan Canyon. It's a wide highway, high speed, also.
Okay, so there's a reason why I asked him to mark an X at the northeast corner. The defendants in this case took the position that Serrano at Duncan Canyon, northeast corner, it actually doesn't mean what you think it means, Mr. Ravi Pudi. Because it actually means a whole different street all the way up here, because the bus actually turns and that's where it stops. And I said, hey, it's where you designate it, doesn't matter, this is where it is. So that's why I asked him to mark it there and started asking him questions based on that. So this is what I call a divergent timeline. And I don't know if some of you have seen this, but this is the best way to start teaching. This is the should have never met each other, right? So what we do is we take the responsibilities in different stages of it and we teach the jury how the right way to do things are. And we get these concessions from the actual school district witnesses, right? This is their duties and responsibilities. We talk about all of them, and they must ensure everything's safe, including the bus stops. And that's because you don't want to get kids run over, right? Pretty simple. So here's a divergent timeline. This is the right thing to do. And let's take it from the boots on the ground, okay? The bus driver. Bus driver observes school kids crossing the street in the wrong spot. What are they supposed to do? Fill out an incident report, okay? Tell the supervisor. Send referral forms to the parents. You gotta tell the parents, right? Don't want them to have their kids doing this. We know the kids can sometimes not listen, so we gotta hold them accountable by making sure the principal's involved, the parents are involved, because kids are scared of their parents, believe it or not. And then start warning the kids, directly admonish them. And then if they continue to do it, you're off the bus. You don't get it, right? And this would be an example of a referral form at the district, and it talks about not crossing with the driver, not crossing where there's signal lights. This form contemplates it. They know what the rules are. Not only do they know what the rules are, but look at this. It comes in different color codes because it's carbon copied. One goes to the principal, one goes to the parents. Everybody's put on notice when the bus driver does what they're supposed to do. And if they did that, these two would have never met. But what actually happened? And then this is the divergence. What did they do? What should they have done? Versus what did they actually do?
I'm going to talk about how you make money, okay? And how you run your practice. Some of you are not going to agree with me. And I'm totally fine with that. But I want to start with talking about an article that I've written that's going to be part of a book that I'm going to have by the time of Cal and I'm going to give out. And I want two concepts. Everybody's got a feed at the trough, and leopards don't change their spots. Okay, everybody's got a feed at the trough. Leopards don't change their spots. What the hell are you talking about? We are plaintiffs' lawyers that want money. The carrier has money. The carrier can't give money without information. We have information, right? And so if we understand that in pre-lit or lit, the faster and more digestible the information we give to the carrier, the adjuster or the defense lawyer, the faster that they have food to eat when they go to their supervisor and ask for money. Right? Now, what is the supervisor, the boss, going to say in a PI case when the adjuster goes, hey, I need 200 grand to settle this case? They're going to go, what, do you have all the medical records? You have all the medical bills? What are the house specials? You got the police report? Are they Prop 213? How old are they? What do they look like? Have you seen them? Right? What's the property damage? You see the property damage photos? If it's in litigation, you got your form ROG responses? Have you taken a depo? Have you done a DME? Okay? So I realized that in pre-lit, every case we get in our office, litigation or pre-lit, the first thing I do is have my clients enter form interrogatories. I send responses to form interrogatories to the adjuster. They're like, what the fuck? I'm like, is it helpful? Well, yeah, this is what I needed. Exactly. Because what you want to do is you want to feed that adjuster with the information that they go to give to their boss, and then they get you the money. Now understand that we all are great at making excuses. My client's still treating. I don't want to be in litigation all this time. I got too much work. We are great at coming up with reasons why not. And if you want to live with that, you ain't going to make as much money. But understand that speed in getting your cases resolved is a function of giving the other side what they need to give you money. Everybody's got a feed at the trough. And so people talk about, what can I do? And I know in COVID, I got inundated with a lot of calls from young lawyers. Holy shit, my practice is over. I don't have any new cases coming in. And I said, have you done the work on the cases you have? Do you have pictures of your client before and after? Defense is going to need them. Have you answered form rogs? Do you have all the medical records? Do you have the relevant records so that the adjuster doesn't have to go through 4,000 sheets of paper to realize that they broke their ankle? Right? All the medical bills. If there is pre-existing injuries, a pre-existing workers' comp, and you want a lot of money, give it to them up front. Do you really think that when they go to get that money from their boss, that boss is not going to say, did you make sure they don't have any pre-existing injuries? Now I know, and I've talked to some people in this room, well, maybe if I hide it, they won't ask. Well, welcome to the world of $15,000 cases. If you want money, you gotta give up the goods. You gotta understand that if you give pre-existing information up front before they ask it, you neutralize. Instead, if they catch you not disclosing pre-existing injuries and then they find out, suddenly it becomes the key to their case. Now, cash flow is king. How do I get more money faster? I expedite that process. So I told these young lawyers in COVID, and there were enough of them, I went on the internet and told them every Friday, I said, go through methodically your cases with the idea of, I've got to provide the adjuster with food. Do I have all the medical records? If not, get it and give them to them. All the medical bills. If not, get it, give it to them. All of those things I'm talking about. Now, what's the other excuse? Well, I got to pull all this together. But you don't know what the policy limit is. Don't wait for months to pull it together. Start handing it to them right away. Because as soon as the policy is implicated, they'll give you the policy. Instead, I see a lot of lawyers waiting 8 months, 10 months to put together a demand package. They could have settled that case in a week. Now, what do I mean by leopards don't change their spots? The corollary to that, the halo effect of understanding what the other side needs, giving them what they need, quickly and digestible, tells them what kind of leopard you are. Now, if you're going on a date, and let's say you're going on a date and the guy shows up late, bad-mannered, looks like shit. What are you immediately thinking? Not a good prospect, not somebody I want to go out with again, probably a loser, maybe has some mental issues, whatever. Now, they may have a very reasonable excuse. They saved a young child. And it's a great excuse, right? But most of the time, you're probably right. And we all know this, right? The best people at doing this are insurance carriers. Because they see all of us leopards 100,000 times a month. And they know that leopards don't change their spots. They know that the lawyer that allows a rear end accident and the adjuster says, well, I think the plaintiff stopped short, maybe 20% comparative, and they take it and they don't file right away, is the same type of leopard that doesn't try cases, doesn't spend money on cases, and if we wait them out, they'll settle. Mike, I don't understand why I'm not getting full value. Because you're allowing the other side to treat you like shit. And they have figured out statistically that more likely than not, you're the type of person that we just wait out. But Mike, I have good reasons. They don't give, statistically, it's irrelevant. You might be the greatest person, they're still going to wait you out. Now, conversely, and Raul, you back me up on this, you know, I hired a defense lawyer My second year of opening my practice, I had a case against him. His firm folded and I hired him. He's now at Ford Walker, but he worked for me for 6 months. Everybody knows Woody Woodland. Everybody knows Woody Woodland? Great guy. I said, Woody, tell me how the defense thinks. He goes, let me tell you how this works. We rely on 95% of plaintiffs' lawyers being absolute imbeciles. Don't follow up when we give bullshit objections. Never take depositions. Don't give us what we need. Don't understand. And I, as a in-house counsel, could not survive unless 95% of the lawyers I dealt with let me get away with murder. Because I have all these files in my office, in the corners, right? Now, 5% of you, give me all this stuff up front. If I don't pay you what you want right away, you file. Next thing you know, I got form rog requests. I got a basic request for production. You notice my client's depo. You offered your client for depo. You offered a DME. Mike, I got to tell you, we can't survive. And we will give anything to get that 5% out of our life. Why is Raul getting $20 million bucks? They want him the hell out of their life. They want me out of their life, right? So when you become the leopard that they understand is the type of 5%, not the 95%, you will start to see they pay like a slot machine, right? Now, if you do those two things and you focus on the faster I do this, the faster I get money for my client, I have a happier client who refers me more work. The faster I get in this work, I get my cost back. The faster I get this money in, I have cash flow. Now times it by 10 cases, times it by 100 cases, times it by 500 cases. For those of you who track how long your case is in your office, if you just move the needle, that the average length span in your office of a case goes from 10 months to 7 months, you'll be shocked at how much more money you have. Feed at the trough. Become the type of leopard that they pay money to. And that's how you make money. Thank you.
Instead of teaching you about trials, he just talked to you guys about how to make money. And that's what you are. You're a business. You're trying to make money. Practice of law is really a business. So what you want to do is you have to look at your top line, your expenses, and your bottom line. So you're trying to run a business. Like Mike said, the faster that money comes in, the less cost you have earning that money. So it's really, really important to practice like a plaintiff lawyer as opposed to a defense lawyer. Defense lawyers don't need to move. They can just sit back, and if you delay, if you don't do discovery, if you don't push your cases forward, they don't have to pay. They're making money on the money that should be in your client's pockets. So what you want to do is you want to push your cases forward and run it like a business, the same way he was just mentioning. I'm going to talk about profitability, but I don't want it to come across like it's a bad thing. We have a reputation as lawyers to be greedy and want to make money. If we are not profitable, our clients will not have us to represent them. So you have to be profitable. Jardy and Keese went out of business. Think about that. One of the largest practices in California. Set aside the stealing. But in order for them to steal, they were losing money. I actually happened to be able to see the financials and the way the firm was being run. They had somebody in the file room making $95,000 a year. I'm not kidding you. I tried to hire the guy because I was trying to give him jobs. $95,000 a year to a guy who was working in the file room. You will not be able to stay profitable unless you run your firm efficiently, especially a contingency practice. So let's go through a case and how we should do things. Number one, especially volume practices. You can't meet every one of your clients, But the cases that you're going to spend money on, you want to meet your clients right away. Every case that you're going to take on, you want to treat it as if one day it's going to go to trial. Isn't that right, Bobby?
Absolutely.
If your client is not likable, if your client is sitting in a courtroom and she or he is going to be disliked by the jury or the judge, you're never going to get anywhere. I'll give you an example. We had a case that we got pre-COVID. The client was in London, and because of COVID, we were not able to meet her in person. We were moving forward through COVID. Case was going along. We spent a pretty good amount of money on it. 2 years later, she's finally in our office. I take one look at her sitting down in our office, and I told Boris, I want this client out of our firm. We had spent $35,000 on the case. I was willing to waive anything but not go to trial on this. And I was right. We did a focus group. Not only did the focus group attendees dislike her, everybody in the firm who was sitting in the viewing room looking at her, they said, oh my God, she's awful. Now imagine going to trial on a case like that. So it's really, really, really important for you to meet your client. Understand what they're all about. And what is the client after? I recently took my aunt's case. She was not attacked by a dog, but a dog jumped on her. She fell and broke her hip. I asked her, I said, let's see what happens and then we'll go. We'll go forward. She said, I want her to pay. I said, no, the insurance company is going to pay. No, I want her to pay because she did this to me by not having her dog on a leash. I said, that doesn't work. We're not in the revenge business. If your client wants revenge, you're making a mistake from the beginning because you're going to have problems later when you're trying to settle the case. Then, so you decide to take the case. You have to set a budget. You have to put a value on the case at the very beginning and set a budget for it. How much money are you going to spend on this? And you have to budget it as if you're going to go to trial and you're going to go all the way. As a rule of thumb, in our firm, we look between 5 to 7% of the case value. We say, this is what we're going to set as the budget. And then we're going to go forward. But it's really important for you to have that budget because you want your case at the end of the day not only to make money for you, but for your client. Everybody has to come out ahead at some point, right? I'll give you an example. We took over a firm that had gone bankrupt. The guy had a $56 million verdict and had gone through personal and firm bankruptcy within months of that verdict. Think about that. Personal and firm bankruptcy. So we took over the firm. I started managing it. Much to my wife's dismay, I used to drive down to Santa Ana every single day from Encino for 6 months. One day he comes up to me and he said, very good trial lawyer. He said, Danny, I'm going to need $30,000 for this case we're going to go to trial on. I said, what's the case about? Woman gets high on marijuana brownies and has an adverse reaction. She ends up in the hospital because the reaction is so bad. And she's so rowdy, they can't control her. And they come and take her to jail. Next day she walks out, she goes into this attorney's office and says, I was sexually molested by one of the male orderlies while I was at the hospital. Again, she was so high they couldn't control her, right? So I said, okay, I'll bite. Let's say you go to trial. What are you going to do with this? Hit it out of the park, $80,000. I'm doing the math in my head. So you want me to spend $30,000 in case costs for a case that best case scenario. Again, the fact pattern I didn't buy anyway. Best case scenario, $80,000. Yes. What's the client going to end up with? Oh, I was going to cut my fees. That's the mindset of someone who goes bankrupt with a $56 million verdict, right? And be realistic about your case values. You rarely want to ask a trial lawyer what the value of that case is. Sorry. Tell me it's not true. Bobby? Do you ask your trial lawyers what the value of the case is?
So trial lawyers, sometimes they like to overvalue a case, sometimes they like to undervalue a case.
What do you mean sometimes?
My trial lawyers in my office are required to meet with me to get settlement authority to settle the case. And when they want to meet with me to get settlement authority, they undervalue the case so that they can overperform and look like they're amazing. And then, other times
What do you mean
when I ask them,
sometimes?
hey, what are you doing for me? La-di-da-di-da. What are you doing for me? Oh, I have all these cases. They're worth all this money. So, humans are biased.
So one thing about, thank you, my tag team partner there. So one thing about trial lawyers, they have to have confidence like you've never seen. They have to walk into that courtroom every single time believing that they're going to hit it out of the park. Every single time. So if that's the mindset that's instilled in your head, very rarely are you going to see the value of the case. In our firm, we have 4 senior attorneys, 2 partners and 3 partners and 1 senior attorney, who will look at every single case we're going to take to see what the potential value is going to be and whether we take it or not. Guess who is not one of those attorneys that looks at their case? Raise of hand. Thank you. So that's the reason we do it. And funny enough, one of the partners who does look at that, she's the most conservative person you've ever met in your life. She thinks tomorrow, the recession is going to come tomorrow and everybody's going to be out of work and nobody's going to make money. I'm making it nice. Sound nice, right? So it's good to have a balance. Focus groups. So you took the case, you saw the client, you budgeted it. Focus groups are not that expensive if you do it right. We have a courtroom in our office. Any one of you, you're welcome to come use our courtroom to do a focus group. No charge. Just get your own focus group. So we do that on cases at the very beginning just to get an idea what are the issues, what would the jury think about the case, and whether we're right about the case, the fact that the case is worth a lot or a little. We had one case that a couple of very good trial lawyers came into our office. We told them about the case and we had a focus group at the same time. I gave him the fact pattern. I'm not going to go into it. And the guy said, if they offer you $200,000, take it and run. The focus group gave us somewhere 7 figures and above. We settled the total cases for $2.5 million. That's the $200,000 case that he said to take. So focus groups are really helpful. They'll tell you what the issues are, sometimes issues that you won't even think about, and it's not on your mind. It's always better to have more brains, and especially a jury, people who would be on a jury, make that decision. So your case is going forward, you have a budget. As your case is going forward, things happen. You have depositions that are going to go against you. You have your expert all of a sudden deciding, it's not exactly what I thought it was. We actually had that the day of the guy's deposition. He changed his mind. So the value of your case can go up and go down depending on what happens. And your budget should be adjusted accordingly. Sometimes all of a sudden the case that you thought was worth 7 figures is all of a sudden a 6-figure case and low 6-figure case. Sometimes the 7-figure case becomes an 8-figure case. So your budget would go up accordingly. So keep your eyes on the case and see what changes, and as it changes, your fact pattern and everything else should change the way you look at it. Here we go. Oops. So the other thing is you have to keep making sure that you're not going to have a runaway cost on your case too. You always have to keep track of it. Depositions are costing you anywhere $1,500, $2,000 minimum. If you're videotaping or recording your depositions, it can go up even higher. There are options for you out there. There are companies out there who will give you basically a non-recourse money for higher cost of deposition, where if it doesn't hit, you don't have to pay. But depending on your case and depending on your appetite, keep that in mind as far as cost is concerned. But it helps you manage that cost. One of the things with regards to liens, we always, whenever we give a case to an expert, I send a letter, tell them do not exceed X number of dollars. If you're going to exceed it, I want to hear about it first. I want to give you the okay to go forward. Otherwise, as you know, experts want to basically run their lives at your cost. Mike talked about that a little bit, I think. It was wise use of 998s and policy limit demands. Depending on where you are, depending on how the insurance company is looking at you, depending on your facts, 998s are really, really helpful. We had a case, we had a 998 first for policy limit. They blew through that. Policy limit was $4.25. Then we had a 998 for $7 million. That expired the night before trial. Go through trial, 2-week trial. Saturday night, Monday morning, you're supposed to give closing arguments. They offered us $10 million. Not a schmuck. Take it every day of the week. The jury the next day, on Monday, said that they were going to give $25 to $30 million in that case. I would still take the $10 million. So would Rahul. So would Bobby. So would Mike. Because you would have to deal with appeals, insurance bad faith, arguing whether policy is blown or not. Go ahead, Bob.
I just want to drop a very important note. Something I learned from Brian Panish like a decade ago. You have a big case with a high policy limit. Do a high-low on your trial and put the high at, if it's a big policy limit, put the high at the policy limit. That way the insurance company sort of has to agree with you to do that because you're protecting their insured's interest. And then, you're guaranteed to get paid. 30 days. Here's that issue.
I'm going to talk about that once we go to trial for using high lows, and that's actually very important and a great use. But as far as before you go to trial, use 998s, use policy limit demands, and use mediation wisely. Sometimes you go to mediation, a lot of times you go to mediation and you don't get the case resolved. But it tells you things about the insurance company's posture, on what they're thinking, and they give things away. So those are things, different ways in order to run your business efficiently before your case goes to trial. So you go to trial. Before you go to trial, you have to really look at, that's the best pay. Basically, you have hindsight. How much have you spent to date? How much is the case worth in trial? And figure out what you're going to go in with. Because the most money you're going to spend on a case is the last 90 days. And in trial, it just goes on crack. I mean, it's crazy how much you're going to spend on a trial. One thing you have to be cognizant of it on that. Don't be married to your case. You've had the case for 2, 3, 4 years. You've spent a lot of time in it. You still have to take yourself out of that and look at it as a third person. Look at it objectively. Is this a case that's worth going to trial on? And then one thing you have to remember is that your very large verdicts, you rarely ever collect. You taught me that. Because you will spend money, you'll get the verdict, and then they'll appeal it. Or we got a $5 million punitive damage award against State Farm. They deserve it. And they sure as hell can pay it, right? Judge struck it down. Now go appeal it. So the big verdicts are worthwhile. They're very, very good to have. But you don't always collect the whole thing. And that's something to keep in mind. So this is what Bobby was talking about. The best way you can eliminate risk when it comes to trial is to go in with a high-low. You know that you're going to get paid at some point. You're basically limiting the risk for the insurance company. You're limiting your upside. Rahul is one of the best at negotiating those high lows in a way that even if when he hits the high, it's pretty high. But that at least takes away the guesswork. You're going to have a limited downside, and you're not going to be zeroed out, and you're not going to hit with a judge that's going to be rogue and is going to go against you. And you'll know that your client is going to have money in their pocket very quickly. So that's something to keep in mind. Same thing, bird in a hand. The $10 million was the perfect example. It's $10 million on a 4.25 policy. Even if you know you're going to hit for $25 million on Monday, you still take the $10 million. I hope that makes sense. Because at the end of the day, someone like you who's really good with numbers, Melissa, will tell you that that is worth a lot more money than fighting for 2, 3, 4 years, chasing down basically a pot of gold that you may or may not get. Talked about that. I love baseball. Some of the best home run hitters strike out, if at best case scenario, 2 out of 4 times. Some of the best ones strike out 3 out of 4 times. In your practice, you can't do that. You can't afford to strike out, not that much. In 8 years, I can count on my hand the number of times we struck out. Think about that. 8 years, 5 times. If 5, maybe 4. That's really important because you have to think ahead as to what you're going to do with each case and how far it's going to go and what the outcome is going to be. And after a while, you become really good at knowing what Kenny Rogers says in The Gambler. You got to know when to hold him, when to fold him, when to walk away, and when to run the hell out of your office. Because some clients you do not want to go to trial on. And that's it. Thank you.